number 8, Doe versus Bloomberg.
Good afternoon, Your Honor.
Good afternoon. Let's wait a moment for your colleague to appear on the screen, sir.
Indeed.
Good afternoon. This is appeal number 8, Doe versus Bloomberg. Good afternoon, counsel.
Good afternoon again, Your Honor. And may it please the court, Neil McGillivray for plaintiff appellant in this matter. Your Honor, may I reserve 2 minutes for rebuttal?
Yes, of course, sir.
Thank you. Your Honor, the question before this court is how to determine whether an individual qualifies as an employer under the New York City human rights law. Now,
so that being the question, do you read Patrovich to articulate the full test for determining whether a corporate employee is an employer under the city's HRL?
Well, I mean, I think it's fair to say that that has been an open question pretty much since the time that the case was decided. And certainly, if you look at the approach from the minority in the appellate division, the analysis they subjected the human rights law to in regard to Patrovich was whether the interpretation of employer using the Patrovich definition was reasonably possible in light of the instruction to favor plaintiffs. So I believe that the question is, was that a reasonably possible construction? And I think certainly for the appellate division, considering that Patrovich is the law, I think it was a reasonably possible construction. I don't know necessarily that it's the only construction, and certainly plaintiff has offered an alternative. But I think in terms of the alternative, the question then would become, while it doesn't go as far as Patrovich in and of itself, the question would be, does it go far enough? Meaning the instruction is always that it has to be construed as far as reasonably possible in favor of.
So what do you think is the test or the rule that we should adopt for the definition of an employer under the city's HRL?
Well, the test, Your Honor, that plaintiff has proposed is the economic reality test derived from the Second Circuit decision, the Irizarry decision. I mean, we think, and we would submit that that is an appropriate test here. But again, to return to the point I made a few moments ago, the question would still remain, does it go far enough? We would submit that that particular test allows, as it were, a middle ground. But the City Council, and it has repeated this instruction over the years to courts, that interpretations over the years have not gone far enough. And while certainly we would—
May I?
So let me ask this question, counsel. So where is the language in the city human rights law that supports the position that corporate shareholders were intended to be held strictly liable as employers for unlawful discriminatory acts of corporate employees? Where do we find, where is that?
It's not there, Your Honor. I mean, the language is not there, but what I would say is this. Obviously, what the City Council—
We divine the intent?
Yeah, well, the point I would make is that the City Council obviously amended the law back in 1991 to make employers strictly liable. Now, at that time, it didn't define what an employer is. Nonetheless, at the time it amended the statute, Patrovich was the law in terms of how to define an employer.
You know, I'm sorry, Judge, is it all right if I—
Please,
go ahead? Yes.
Judge Fahey.
The way I understand Patrovich is that it's a two-part court test. One part says if somebody's an employer if they have an ownership interest, or somebody's an employer if they have the power to do more than just carry out others' decisions. Do you agree with that? Is that the
Yes.
way you read it?
It is wrong.
In some ways, I think those two definitions seem to be contradictory to each other. Of course, someone can have an ownership interest, and within the context of the organization, it's quite common to really have no more power than to carry out other supervisors' decisions. People own stock in companies, and what I'm concerned with is the contradictory nature of that test in and of itself. And then secondly, I have a hard time getting my mind around a reading of modern corporate structures that allows anyone who is essentially a shareholder to be dealt with as if they're an employer on a day-to-day basis. It seems to be such an enormously broad test that it has no limitation in our modern economic reality.
Yes, well, Your Honor, as it happens, and as I hope plaintiff made clear in her papers, we tend to agree with that. I think for the appellate division, Petrovich is and was the law when it made its decision. We certainly have argued that if you inquire deeper into the origins of Petrovich, it was in terms of how it framed the test or expressed the test, it was referring to the economic reality test as it had been articulated or developed at that particular time. So it refers to a number of cases or cites a number of cases where the economic reality test was applied in the context of FLSA cases. It also referred to at least one case where it was applied in the context of the ADEA. Now, obviously, the law has changed on the federal level in regard to that statute, but I think the point is well made, and we certainly would tend to agree with it.
One of the problems is with Irizarry is I thought that was an FLSA case, and it had certain statutory requirements that would be different from anything that we would do here, because I think here we're implicating a common law interpretation of what we mean by liberal interpretation and what the statute means by employer. And it's a somewhat different setting, I guess. So applying that here, I'm having some difficulty with that. Tell me how you get through that.
Well, what I would say to that, Your Honor, is that obviously certain FLSA specific factors have been developed over the years. I think the test is a broader test, meaning it's not, the test in and of itself is not confined to one particular statute. And I think if you look across other statutes and other areas of employment law, there are various tests that have been developed to identify employers, and they are used interchangeably across different statutes. Now, of course, here with the FLSA, it's a very specific statute, and there are specific factors that have developed to apply to it. I don't think those factors are necessarily appropriate with regard to the New York City human rights law, but I think that it would be possible to develop factors that would apply in this case in the same way. I think the principle is a sound principle in that, and again, we have expressed it in quite general terms, which is that if an individual has operational control over the way in which a company interacts with its employees, we believe that the employer, the individual in that case, is properly held liable. And we certainly think that that is what the City Council has instructed in terms of how the term should be interpreted.
If I may ask a question, Judge.
Rivera.
Thank you so much. Counsel, I want to follow up on this from a different angle. I guess the difficulty I'm having is that there's certainly a whole line of case law exploring the issue of a supervisor's liability when the supervisor is nothing but a supervisor, but did not themselves participate in the conduct that the complainant, the plaintiff, is alleging is violative of whatever anti-discrimination employment statute they're referring to. But here, and you can correct me if I'm wrong, as I understand this complaint, yes, of course, you're arguing that he fits at a minimum under some version of the way we might read Petrovich, but you're also arguing that Michael Bloomberg is responsible for having set that culture in place, that indeed he really is responsible for the opportunity and the environment that allows for this kind of conduct to be encouraged, to have occurred, and to not be disciplined, which strikes me as somewhat different, right? It strikes me that the complaint is really going on about his own conduct, not merely as a shareholder who might have some control. I mean, after all, the business is Bloomberg. He built the business. He's been very public about the fact that it is his company. So as I understood the complaint, it is really in many ways also about what he has done. So if you could perhaps address how that might inform the rule you're proposing and the way we might want to think about what the council had in mind with respect to who should be strictly liable and who's covered by the statute.
Yes, and Your Honor, I would agree with pretty much everything Your Honor has just said. Mr. Bloomberg, in this case, is not somebody who is a defendant in this case simply because he holds a particular title or simply because he owns a certain amount of stock in the company. He's in this case because of what he did. Now, in terms of what we don't dispute is that he did not personally harass plaintiff in this case. There's no suggestion to that effect. And I would suggest to the court that this issue was raised with him, and again, it's beyond the record, but it is a matter of public record, quite recently in the context of the Democratic primaries, where his defense essentially was, I didn't harass anybody, I may have made certain comments, and I think that kind of behavior is no longer good enough. It certainly wasn't good enough in the context in which he offered his defense, and we don't think it's good enough here either. And I think that in terms of a company's culture, certainly Mr. Bloomberg over the years has received many plaudits and taken much credit for the culture he has installed within his company. And there are positive aspects to it. There's no question of that. But there are also negative aspects to it. And this is one of them. And we certainly think that he should be held responsible. Now, that does not mean ultimately at the end of this case that he will be found responsible. But at this juncture, he does have a case to answer. We certainly believe that. And again, the point being, he's not here simply because of his title or simply because he owns stock. And I think that is a legitimate concern. Again, if you take the proverbial 1% owner of stock, I think there would be a real issue for someone like that to be made a defendant in a case.
Well, plaintiff, just to follow up, excuse me, if I may, just to follow up, I just want to be clear. Of course, plaintiff did not sue any other shareholder, correct?
No.
And didn't make any other claim that any other shareholder had set that culture and so forth. Correct?
Absolutely not. Absolutely not. And okay. The only reason Mr. Bloomberg was sued was because of what he personally has done. Okay, and then, so then this is my other question. Given the way you've now clarified sort of how he is a defendant, what the allegations are of as he is a defendant, what's the policy that would be furthered beyond the general policy of anti-discrimination law and the city council, as you've correctly said, and as the court has said over and over, a broad, expansive reading of the city's human rights law? What's the public policy that's furthered by saying that this particular defendant giving these allegations is properly considered liable under the statute? Well, Your Honor, I think accountability matters. And I think the accountability of the people who sit at the top of organizations and set the tone and set the example matters. And I certainly think it furthers the policy of the city council, not simply to hold lower level supervisors liable for their conduct, and obviously they should be held liable. But there shouldn't be a cutoff, as it were, that if you're elevated enough within a corporate hierarchy, therefore you're insulated from liability as a result of your own conduct.
Judge, may I ask a question?
Judge Stein.
Counsel, but I guess what I don't understand is how that adds to the corporate responsibility. So whether Mr. Bloomberg himself is personally liable for creating a culture, that doesn't, it seems to me, when you're talking about incentivizing or disincentivizing conduct, if the corporation is ultimately going to be liable for that conduct, what does it add to have the individual responsible in terms of really anything?
Well, Your Honor, what I would say is obviously in the eyes of the law, a corporation is a separate personality, a separate entity. But I think the reality is that a company, a corporation is its people. And to the extent that I would not suggest that holding somebody such as Mr. Bloomberg personally responsible or personally liable is the only incentive for a company to accord its behavior and the behavior of its employees with the law. But I think it's a particularly strong incentive where those that have the power to set policies, set the culture within a company, know that if they don't do what they're supposed to do according to the law, that it's not simply that the company will be held liable, but that they may be held personally liable. I think that is a particularly strong incentive. And again, to compare with the FLSA, certainly once more we would accept it's a quite different statute. But I think if you look at it from a purposive point of view, the reason you have individual liability there is that the determination has been made by the courts that the purpose sought to be served by the legislation is furthered by individual liability and individual accountability.
Let me ask you a question. If you're looking for personal accountability, aren't there other provisions in the city human rights law that would create that aren't based on vicarious liability? So isn't that accountability already there? If, as you say, this is based on his conduct in this, then isn't that covered already in the statute without adding vicarious liability?
Well, it does not appear as those particular provisions have been interpreted that would be the case. They all require personal participation in the offending conduct. And in this case, we don't have personal participation.
Well, for vicarious liability, yes, but might it not be considered, for example, aiding and abetting, or something of that nature? By creating the culture, and then you might have liability, but it's not based on what the other person did per se.
I agree, Your Honor, except that that particular provision, the aiding and abetting provision, has been, without exception, interpreted to require personal participation.
Chief, if I might.
Yes, Judge Wilson.
Counsel, in your view, would the complaint be sufficient if it omitted all of the allegations having to do with Mr. Bloomberg's conduct and left only the ones having to do with his status?
Your Honor, would you mind repeating the question? I'm not sure that I fully understood it.
Sure. We've been talking about, Judge Rivera raised that the complaint has a lot of allegations in it about Mr. Bloomberg's conduct in setting a toxic environment and so on. It also has allegations that Mr. Bloomberg is the owner of the company and so on. If we omitted all of the former and retained the latter, would the complaint still be sufficient?
That is difficult to say in that, well, it certainly would be sufficient under the bare, as it were, Petrovich test. It would be sufficient. If something more is required, meaning if the elements set forth in Petrovich are necessary but not sufficient and something more is required, I think, and again, the test we have proposed is the one from Irizarry, that one would need to show that he has control over the company in such a way that it affected the terms and conditions of plaintiff's employment. So there would need to be something within the complaint addressing that. Now, that I think, however, is a separate issue from culture. And we have alleged in the complaint that he was directly involved in employment-related and in particular discrimination-related decisions within the company. So I think that allegation alone would suffice without the allegations as to the culture he created.
Thank you, counsel.
Can I ask just one
Yes,
question,
Judge Fay,
counsel?
yes, of course.
A short one. The way I read the human rights law is that it requires that its provisions be construed liberally. I think the language it uses is that it requires, quote, an independent liberal construction in all circumstances, end quote. So listen, my understanding of what's liberal changes from time to time, and it historically changes in our own life. It changes from century to century. And what's your understanding of what that means as to how we should construe this statute?
Well, to put it bluntly, if it's good enough for an individual employer to be held liable because employees are not paid their full wages, it's certainly good enough for an individual employer such as Mr. Bloomberg to be held liable in this case.
I don't know. I don't understand what that means. How does that tell us what a liberal construction is?
Well, liberal construction is what the City Council has asked for is that it be liberal, as I understand it, and as the City Council has instructed, is that it has to be construed in favor of plaintiffs. Now, by definition.
So let me just stop you there. So you're saying that the statutory construction that's being advocated here says that the court should favor one side as opposed to another in a litigation question?
Well, I'm quoting, Your Honor, from the Albunio case, and the language, and I'll quote the exact language. It must be construed broadly in favor of discrimination plaintiffs to the extent reasonably possible. Now, that particular analysis was enshrined subsequently in the human rights law itself. Now, I understand the question Your Honor asks which is the City Council asking that one side be favored over another side? And the simple answer is yes. I mean, that is what the statute says.
Well, wouldn't your argument be that what you're asking for here is a deposition, and that's a procedurally liberal approach, but not a substantively liberal approach as to the application or the consequences of it?
Yes, I mean, certainly a limitation with the record presented to the court is that there has been no discovery and there has not been a deposition, and that does present a real challenge to this court, and we would certainly argue that at the least the case should be allowed to continue with Mr. Bloomberg as a defendant so that a record can be developed. And again, at the very least, that would allow whether this court or another court to better determine whether he should be held liable as an individual.
Final question. Am I, and I may not be right about this, am I right about the factual part of the record, which is that during the time when the petitioner here, the complainant, the plaintiff, worked for the company, Mr. Bloomberg was mayor during that whole time? Is that correct?
No, Your Honor,
No?
only part of that time.
All right, thank you.
Thank you, counsel. Counsel?
Yes, Your Honor, and may it please the court, my name is Elise Bloom, and I am here representing Mr. Bloomberg. There's really one narrow issue before the court today, and the issue is whether or not an individual owner or a person with a high-level title can be held strictly liable as an employer under Section 8-10713 for the conduct of another employee in the corporation that he or she did not condone, encourage, approve, or even know about. Now, the appellate division answered that question no. And we ask this court to affirm the appellate division's decision and dismiss the complaint against Mr. Bloomberg.
Keith, may I ask a question?
Judge
Sorry.
Garcia?
Counsel, I think if you look at the cases and the decisions below, you see the courts really struggling to come up with a test here. And I think one of the reasons is the city human rights law is so unique in terms of the liability it imposes. And I think there are difficulties with each of those tests because it's so unique in the terms of the strict liability, particularly for an employer. I read Petrovich somewhat differently and more nuanced in terms of what that test that people are citing actually applied to. But with respect to your or the majority's position below, it does seem, as the dissent I think pointed out, difficult to have a preliminary test for employer in a strict liability context that contemplates some type of fault. So before we get to whether or not you're strictly liable, we have to determine if you participated in the underlying offending conduct. Seems a difficult test to apply.
So, Your Honor, I understand the appellate divisions conclude where the appellate division landed, and I believe they landed in the right place. However, under the express language of the human rights law, the city council was very precise in setting up those instances in which an individual can be liable for his or her own conduct. And they were precise and they were explicit. And there are 3 places in the city law. And this
I understand that. I understand the liability. And I think, again, in terms of talking about conduct and culture, there were aiding and abetting charges, counts as I understand here, that aren't at issue on this appeal. But just getting to the liability of an employer, and the liability under that statute is broad, especially that first prong, which says supervisor, manager, strict liability. It seems to me difficult logical argument to make. And I'm not saying where you come out at the end, but in terms of applying that majority test, we're going to look at your participation in offending conduct in determining whether or not to get to the threshold issue of whether or not you're strictly liable.
I think there's 2 different points. And the rule of law that we're advocating is that for purposes of employer under 8-10713, that provision on its face, as construed and harmonized with the other provisions in the New York City human rights law, does not provide that an individual owner or executive can be vicariously liable as an employer for the actions of another corporate employee. I mean, to the extent that this court is inclined to read into the definition of employer a meaning that might encompass an individual owner or executive of a company, I mean, the only reasonably possible construction requires some level of personal culpability for the specific conduct alleged by the plaintiff. And
Judge, if I may ask, I just need to interrupt here for
Okay,
clarification purposes. When you say an individual owner, do you mean like owner as in the sense of a shareholder? Because obviously the majority distinguishes an owner who's the sole owner of their company. So is that just to clarify?
I'm sorry, if I was unclear on that point. To the extent that we are talking about a sole proprietorship, I believe that an individual, provided that they have the requisite number of employees, would be an employer. But in this case, where you have a corporate employer who is a defendant in this case, and you have the alleged wrongdoer who is a defendant in this case, the statute does not provide for individual liability for somebody simply because they are a shareholder or they hold a high level within the company. I mean, the statute tells you when an individual.
What if you've got a business where you've got 2 partners as opposed to the sole proprietorship? Are they both liable, strictly liable?
I believe, under the strict reading of the statute, if they were together the employer, Potentially, yes. But in terms of the strict liability piece of it, I mean, they certainly could be liable under any of the provisions that provide for it.
So then if discovery showed, there's not been any here, but if discovery revealed that the defendant, Michael Bloomberg, is not an ordinary shareholder in the sense we mean, some pension plan owns one share, that he really functions as the kind of employer that has a particular level of control, would that change the analysis?
There are no allegations in this case which would support a conclusion that Mr. Bloomberg was any way involved in any of the acts that happened in this case. And
no, I'm not talking about the acts. I understand your argument, and I think counsel has conceded that and said it over and over, that that's part of the issue of why they've crafted their arguments in this way. But I'm asking you if discovery revealed, in fact, that as a shareholder, he can really functions essentially closer to, if not a sole proprietor, right, owner, as an owner that's on the level of partners who have equal control and say in how a business is run.
it's our position that based on the very, very detailed allegations in the complaint, that the only purpose of discovery in this case would be to try to uncover some fact, and that's not the purpose of discovery, that the court has to take the allegations of the complaint as pled. And as I said, in this case, the allegations are very, very detailed.
Counsel, can I clarify clarification a bit? I think the question being, if you have a partnership, right, a law partnership, is that really different as an entity? Because let's say it's 250 people in that partnership, but you have a managing partner or a few managing partners. What would your view, I mean, that's the corporate entity in that case, what would your view of the liability of the managing partner or partners be under your interpretation of the city human rights law?
Under our interpretation of the city human rights law, the liability of an individual partner would be determined under one of the three sections that provides for individual liability for either engaging in the act, aiding or abetting, or retaliating. That right. There would be no basis to hold that individual liable as an employer for purposes of imposing vicarious liability.
So it doesn't matter what the corporate form is. If it's a corporate entity,
that's correct.
Liability is with the entity. And to, let's call it, and this isn't what it is, but piercing the veil, or to get to an individual because of their status in the entity, you need some type of conduct making you liable under the substantive provisions of the human rights law. That's your position.
That's our position. And
can I ask you to clarify one other thing? In this particular case, in the complaint, there are allegations, and the plaintiff is arguing that there are specific allegations about Mr. Bloomberg's conduct. Are you saying that they cannot go forward on those allegations, or are you saying that they are only that they failed to state a cause of action with respect to allegations only of vicarious liability?
Our position is that for purposes of vicarious liability under section 8-10713, that they have failed to state a claim. And I would point out that there had been an aiding and abetting claim that had been brought against Mr. Bloomberg. That claim was dismissed. That dismissal was never appealed. And if you take a look at the allegations, these allegations of alleged corporate culture, I mean, they really fall into two categories, both of which are completely insufficient to tie Mr. Bloomberg to anything that's alleged to have happened in this case. One category are some things that are cherry-picked from media articles that pertain to things that happened back in the 90s or the early 2000s, well before the plaintiff ever joined the company in 2012. The other category refers
Look,
to.
well, look, counsel, they may not be able to prove it. The question is whether or not the complaint is sufficient to get them past that threshold, right? And so if they're arguing that a particular defendant has created an environment in which the conduct alleged to be discriminatory is encouraged, not disciplined, and expected, right? That's sort of the kind of argument they're making. That strikes me as different from saying, oh no, they can never show that, right? That's a different question. That's a question of proof.
But the question here is, accepting your position, the question here is, are the allegations that they've made sufficient to even get them to that point? And they are not, because if you look at those allegations carefully, what you will see is that there are a series of media articles that talk about unrelated old conduct. And I will point out, just so the record's clear, there's some reference in paragraph 34 of the complaint to 2015. It's wrong. It's talking about an article from November 1st of 2005. They've got a bunch of unrelated things from media articles that have.
Counsel, assuming, I want to circle back to Judge Stein's question, assuming that the court disagreed about the sufficiency of the allegations as a threshold matter, could they then proceed on those allegations, not for purposes of vicarious liability, but as an argument of his own conduct, separate and apart from aiding and abetting, not as an aider and abetter, but for his own?
I do not believe that the allegations as stated in the complaint would allow them to proceed under section 8-1071, which is the section that says that an individual it shall be an unlawful discriminatory practice for any employee to engage in any kind of discriminatory conduct. And I do think it's worth mentioning that they have not brought such a claim against Mr. Bloomberg, and that they themselves concede and they've conceded here today, that he had no involvement. We have a corporate employer here who the plaintiff alleges was her employer. We have the wrongdoer here who the plaintiff alleges was employed by the corporate employer. The question we're talking about here is the vicarious liability question. And I did want to go back to some of the questions about Petrovich for a moment, because I do think that that's important. It's important. There's several things about the Petrovich case that make it inapplicable here. Starting with, the question in the Petrovich case came up under the state law as opposed to the city law. And this issue with the state law is that the only way for an individual to be liable for his or her own conduct is if they are an employer. And the problem in Petrovich, and the point that gets overlooked time and time again, is that what the court was looking at is they had the person who was the alleged wrongdoer. And the question was, can we make that person responsible for their own conduct under the city law, under the state law? And under the state law, the only way to do that was to determine if they could be an employer. And so the court was grappling with the question of, at what point, how high up in the organization does that person have to be responsible for their own conduct? And so that was where the whole discussion about, could they be considered an employer? Under the city law has specific provisions for individual liability. We're not talking about those provisions here. Nobody's made, there was a claim made under one of those provisions. That claim was dismissed and not appealed. The question here is one of vicarious liability. And even if you look at the economic realities test, and even if you go back to that Irizarry case, the Fair Labor Standards Act case, if you look at the language in that case, the court was very clear that it requires some degree of individual involvement in the company that affects the terms and conditions of the plaintiff's employment. And the plaintiff here concedes that that is not present with regard to Mr. Bloomberg.
Counsel, where, if at all, does Griffin fit into this?
So in terms of Griffin, and I assume you're referring to the common law test and how that might apply to the definition of an employer, I think one of the most important parts of Griffin actually comes out of the dissent in that case. And I say that because In the dissent, it was pointed out that we must give meaning to every word when interpreting a statute, but we cannot add words or interpret a statute in contradiction with the legislature's express manifestation of its intent. When you look at the city law, the city council was specific. These are the times that an individual can be personally liable. The city law was also specific in terms of the use of owners and managers, because if you look at the public accommodation provisions, you see that the statute specifically says an owner or a manager can be responsible for discriminating in a public accommodation context. That is completely different. There is in the vicarious liability section, it talks about employer only. And it says an employer may be liable for the acts of its employee or an agent.
So you say, so Griffin, the Griffin factors have no relevance here. Is that your position?
I do not believe that the Griffin factors inform an interpretation of the city law, but to the extent that this court is inclined to consider the Griffin factors would support the dismissal of Mr. Bloomberg, because again, they would require some degree of participation in the underlying conduct, which is not alleged to be present here.
Judge, could I ask on
Judge
that?
Fahey. Mhm.
Could Ms. Bloom, could we just stay on the Griffin test for a second? The way I understand that case, it's a 2017 Court of Appeals case, I believe, that was referred by the Second Circuit. The way I understand it is that we adopted a common law test that said the essential element is the right of control. Would you agree with that?
I would say that was one of the four elements that the court adopted. That's correct.
So if that's the case, why doesn't the plaintiff get to ask the question of the employer here, or the chief executive officer, of whether or not he exercised any control or created a hostile environment in some way?
For two reasons. First, going back to the test in Griffin. The test in Griffin had four components to it.
Mhm.
The selection and engagement of the servant. It's undisputed in this case and alleged by plaintiff that she was hired by Bloomberg LP and interviewed by the alleged wrongdoer, Nick Ferris. The second, the payment of salary or wages. There's no allegation whatsoever that Mr. Bloomberg had anything to do with the payment of her salary or wages. The power of dismissal. She had no allegation that he had anything to do with the terms and conditions, her hiring or her dismissal. And then the fourth factor that you point to, the power of control of the servant's conduct. Again, there's no allegations in this case other than reference to some media articles that Mr. Bloomberg had controlled in any way, any aspect of the plaintiff's case. And I'll stop there. So I believe that even if you were to apply the Griffin factors, you take the allegations as pled in this case, Mr. Bloomberg does not, under the clear language of the city human rights law, he would not qualify, he would not be considered an employer for purposes of imposing vicarious liability. And to allow him to remain in this case simply because there may be a possibility that the plaintiff could drudge something up in discovery runs counter to every litigation
Judge,
principle.
if I may ask a question?
Sure.
Well, I was asking the judge. Thank you.
Sorry.
Go ahead, Judge, you're there.
Thank you. So, counsel, let me just ask you this hypothetical. Is counsel still? Yeah, there you go. Let me ask you this hypothetical. Let's say you have an employer who is the founder of a company and sets as a practice that women shall not be appointed to managerial positions, and then leaves the company but retains shareholder control. Can that person be sued under the city human rights law for vicarious liability?
I do not believe that that person would be considered an employer for purposes of vicarious liability under the city law. I believe that if you could establish that that person in some way was involved in the challenged employment conduct as to the individual plaintiff, you could sue them as an individual.
Well, I'm sorry, I wasn't clear. The assumption in my hypothetical is that you have a plaintiff who sues because they were not appointed to a managerial position because they are female based on their sex.
I think if you could establish a connection more than just there was a founder of a company at some point who set a practice, and then at some point in the future, this is what happens, not even knowing whether the founder is there or not there. I do not believe that those facts in and of themselves.
In my hypothetical, I said they then become a shareholder.
I believe under your hypothetical that individual would not be considered an employer for purposes of section 8-10713, and that to the extent there could be liability, that liability would have to attach to one of the specific provisions that provide for some type of at least minimal culpability.
Thank you, counsel. Counsel, you have your rebuttal?
Yes, thank you, Your Honor. Your Honor, to pick up on Judge Rivera's hypothetical, Mr. Bloomberg's position here is that, to take it one step further, if he set the particular policy described in that women could not be appointed to particular positions, but then somebody else within the company applied it to an individual employee, Mr. Bloomberg's position is that he could not be sued for that. The only person who could be sued is the other individual who applied the policy. The setting of the policy, even for that person to remain as CEO, that the setting of the policy alone would not be sufficient for liability. It's only the person that applies it in the individual case. And I would, to make a broader point, I think the difficulty here is that Petrovich obviously ruled that individuals in certain circumstances, and obviously there's dispute as to what those circumstances are, can be held liable as employers. And the City Council said that employers are to be held strictly liable for the conduct of managers and supervisors. Now, that is a difficult circle to square, but to the extent that an employer or an individual such as Mr. Bloomberg is not to be held strictly liable, that would mean, in essence, overturning Petrovich, unless Petrovich is to be confined purely to the state human rights law. And I don't think that
Judge,
is...
if I may ask a question, Judge, let me just go on the way you were trying to get to the hypothetical I posed. If I was going to be if I was going to try and answer it from the defendant's side, given what you've said, wouldn't your adversary's response be, well, they first came up with that policy, but the reality is that the corporate entity adopted the policy. That's the employer, and at the time of termination, that's the proper defendant, in addition to whoever otherwise aids and abets. There could be another supervisor who aids and abets, or someone else who aids and abets, and whoever otherwise is responsible for actualizing and implementing the policy. But once, in my hypothetical, they moved on to shareholder status, the corporate entity is the employer, because I think that's what the majority was struggling with. This corporate entity is your employer. What might be your response to that?
Yes, I mean, I do understand the struggle the court below had, and I think it's a legitimate struggle. But I think that the problem with the decision below is that it essentially rewrote the statute. I mean, it took a standard of liability that had been rejected explicitly by the City Council, and as it were, brought it back in through the back door, in that as a way to define an employer. I think as a starting point, in terms of the present analysis, I don't think there's any serious dispute that the majority below got it wrong for that reason. Now, the challenge, of course, is where to draw the line. And I think that certainly the privilege, and it's a privilege, we're not in Lochner territory, it's not set in stone, it's not a constitutional right, limited liability, but it is something that is or should be properly considered in the context of the city human rights law. But the question is where you draw the line. And to go back to my previous point, the line, considering that the city human rights, or City Council, I should say, have said that employers strictly liable for the conduct of managers and supervisors, the only way to draw the line in the way that Mr. Bloomberg is proposing is to say that individuals cannot be considered to be employers in the city context, and that they can only be considered as employers in the context of the state human rights law. And I don't think that's a tenable conclusion here. And I would say as well, in terms of another point that has been made in terms of Griffin v. Silva and the test there, and the essential element there, as with the Irizarry case, as with most of the tests that have been crafted, is that of control. Now, and it's not simply about immediate control. And I think that is an important theme, that when courts look at personal participation, they're looking at an immediate connection between the plaintiff or the victim and the defendant. That we don't have here. We don't have that immediate connection between Mr. Bloomberg and the plaintiff here. But that alone, the fact that the connection is not immediate, that the control is not immediate, should not suffice to insulate him from liability. Essentially, what you're doing is that you're pinning all the blame on lower level employees, lower level supervisors, and you're insulating the people at the top, the people who set the course for companies, whether it's by way of setting policies or establishing cultures, from liability. And I do not think that accords with what the City Council has asked for in terms of its vision of the justice that discrimination plaintiffs are entitled to.
Thank you, counsel.